What are the biggest challenges in international patent licensing? Imagine trying to share a secret recipe with someone across the world, but each country has its own rules about what can be shared and how. That's similar to what companies face with international patent licensing. The main issue is that there is no single global system for patents. Instead, each country has its own laws, rules, and standards. This makes it tricky to protect inventions worldwide because what is patentable in one country might not be in another. For example, an invention that qualifies for a patent in the United States might not meet the criteria in Europe or in developing nations. This means licensing agreements need to be carefully drafted to fit each country's rules, which can take a lot of time and money. Enforcement is another big challenge. If someone infringes on a patent in one country, it might be easy to stop them there. But in countries with weak legal systems or limited patent enforcement, it can be very hard to take action. Sometimes, local courts might not have enough experience with patent cases, or the process to sue for infringement can be slow and costly. This uncertainty makes licenses hesitant because they might spend a lot of resources without getting proper protection or compensation. Then there are costs and administrative hurdles. To license patents in multiple countries, companies often need to file separate patent applications in each place. This involves paying multiple fees, which can add up quickly. Managing all these filings and keeping track of different deadlines and legal requirements can be overwhelming. Plus, licensing terms might need to be adjusted for each jurisdiction, adding more complexity. Legal concerns around antitrust and competition laws also come into play. Different countries have rules about how patents can be licensed. For example, some laws restrict exclusive territories or tying licenses to other products. If a license agreement violates these rules, it could be declared invalid or lead to penalties. Licenses must be very careful to structure their deals correctly to avoid legal trouble. Managing contracts across borders can be tricky too. Licensees in different countries might not follow the rules, or local laws might limit the licensor's ability to enforce the agreement. Sometimes, licenses want to include improvements or cross-licenses, but legal differences can make this difficult to manage internationally. Another big hurdle is that there is no such thing as a worldwide patent. Even with treaties like the Patent Cooperation Treaty, which simplifies the application process, patents are still granted country by country. This means licenses need to negotiate and enforce rights separately in each jurisdiction, which can be very time-consuming and expensive. Political and economic risks also matter. Changes in government policies, economic instability, or weak intellectual property protections in some countries can make licensing risky. In such places, licenses might hesitate to enter or may need to use alternative strategies like joint ventures or direct investments to protect their interests. All these challenges show that international patent licensing is not just about having a good invention. It requires careful planning, legal knowledge, and understanding of local markets. Companies must weigh the benefits of expanding globally against the hurdles of protecting and enforcing their patents across many different legal and economic environments.